If you are named as an executor in an estate or a beneficiary of an estate, and the person who died has more debts than assets, does that mean that you're personally responsible to pay the debts of the deceased person? Hi, my name is Laura Hurd, and I'm an attorney who has practiced probate and family law in San Antonio, Texas since 1987. And a friend of mine recently approached me with that very question. She said, my daughter has been named as a beneficiary in a will, and I know that the person who died had more debts than assets. Does that mean that my daughter is going to have to pay that person's debts? And if I'm the executor of the will, does that mean that I have to pay that person's debts personally? I'm happy to tell you that the answer to both questions is no. But there are some exceptions. However, for the most part, the only person responsible to pay the debts of the decedent are the decedents and the decedent's estate. Now, the executor has a certain duty to gather up the assets, figure out what the debts are, and pay the debts in a certain priority. In other words, if there is not enough money to go around, some creditors will get paid before other creditors, and some creditors may get nothing. And those creditors are just out of luck. You can't put a dead person in bankruptcy. So they just get nothing and walk away. There's nothing that they can do. But many times the creditors don't properly present their claims, or they don't have the proof of their claims. And so sometimes, even though they make a claim and say that there is a debt, the executor is able to negotiate with them to receive less amount, or to say, I'm sorry, but you didn't make your claim properly, or you can't prove your claim, so you're not going to get paid at all. And there is the possibility that the beneficiaries then will get some of the estate, maybe not everything that they were supposed to get under the will, but they get whatever is left after the creditors have been paid. Now, if there is no property left after the creditors are paid, then the beneficiaries get nothing. However, if the executor has paid out the money to the creditors, they are not personally responsible for the rest of the debt. An exception exists in that if a person has wrongfully managed the estate as executor. For instance, I had a client one time who gave out all the property of the estate and then found out that there was an IRS bill outstanding. And the IRS said, hey, we want our money, and if you don't get that property back for the beneficiaries, then we're going to take it from you personally. Now, that was a little different situation because the estate had enough money to pay the IRS. It's just that the executor had given that money to the beneficiaries without satisfying the IRS first. And so therefore he had to go back to the beneficiaries, get the property back from them to give to the IRS, which made a lot of people mad at him. But it was either that or pay it personally. The other exception is sometimes an unscrupulous creditor will make you think that you have to pay those debts and will ask you to sign a contract, or will guilt you into signing a contract, trying to make you feel like it's your responsibility or your duty to clear that person's name or something. And so if you do sign a contract agreeing to personally be responsible for the debt, then you're going to be responsible. But you should never do that, because legally you are not responsible. You didn't sign for that debt. You didn't get the benefit of that debt. And as executor, you should only sign things as executor. Every time you sign something, you should write under it as agent for the estate or as executor for the estate, and not sign it personally, and you're not personally responsible. I hope this helps, and if you like this video, please click on the like button below, and if you would like to hear more videos like this, please click on subscribe. Thank you.